7. You guys. Sweet. Right, we will put timestamps in the chat at 6 minutes and 8 minutes, and anything you say after 8 minutes and 15 seconds obviously is going to get ignored, so time yourself as well. Okay, whenever you guys are ready, I'd like to call on the first speaker of the affirmative team to get things started. Awesome. I'd now like to call on the first speaker of the affirmative team to open this debate.
This program inculcated a conservative, economic, social, environmental, and legal bias in many legal systems by virtue of the fact that it instructed many of the most powerful and influential federal judges. That is enormously regrettable. What's the counterfactual in this debate? And we're going to hold pretty strongly in this debate that it's likely nothing for two key analytical reasons. The first is the unsatisfying pointing to the info slide empirically. Nothing else has existed of this kind of format. Nothing has formed after its discontinuation, which suggests there's no organic incentive for it to exist. But secondly, it was a voluntary program. It was not pushed by any particular law society or any particular government. It was something that was created by a set of economists to influence, like in its absence, if we regret it happening, it does not have an alternative or second form. That notably forecloses any argument about there would be something worse that would happen in the counterfactual. Let's not have that debate. Okay, a couple of questions of setup. What was the program? What did it teach? Why were judges changed by it? Then overwhelmingly, what was the conservative bias and why was that harmful? What was the program? What did it teach? How was it taught? We say it was taught with a hugely neoliberal lens with a bent towards pro-business, anti-regulatory, and pro-crime deterrence policies, and fundamentally a pro-market lens. Why is this so? Firstly, because it's partially just empirically true from the info slide. Like Milton Friedman, as one of the most prominent figures as a part of this program, is the flagship neoliberal monetarist economist who advocated for those policies, who advocated for their implementation in the economy. But secondly, this was a policy that had its heyday in the 1990s, where neoliberal economics was at its most cultural and political power, and it was the least questioned. Think the high watermark of Clinton, of Blair, that kind of political climate where there was the hope of globalization, of free trade, of the end of history, the end of the Cold War. That kind of economic environment led to this being taught very heavily. So what was taught very specifically? We think it probably looks like three things. First, it was focused on a cost-benefit analysis of people's economic actions, which is the fundamental microeconomic claim that people are rational and that they make utility maximizing decisions in all cases. I'm going to explain how that interacts with crime later, but hint, people are not always rational, and that idea is harmful. Secondly, it's the idea that the market is the best mechanism for pricing, and therefore advocates for government and legal non-interventionism into markets. For instance, it makes the claim that monopolies are okay because there's always the threat of entry of another, more competitive business, and because there are certain pro-neoliberal benefits of this. For instance, economies of scale or productivity. Thirdly, it teaches Coase's theorem of property rights, and which is the advocacy for a specific set of people to control property to avoid external harms. For instance, individuals having control over land as compared to governments, and governments, rather than intervening to regulate people's actions with how they use land, incentivizing them to do so. So it advocates that governments should protect private ownership of land and try to incentivize rather than regulate. That has environmental effects. I'll explain later. Why is it the case that the set of judges who listened to this Manne program were changed by it, were influenced to hold those beliefs more strongly than they previously were? And I guess it's important to ask the question, without this program, would judges have this understanding of the world anyway? And we think that's not true for a couple of reasons. Firstly, because of the nature of the adversarial judicial systems, where ordinarily both sides give arguments in favor or against particular actions. And in the absence of specific strong economic teaching that advocates you interact another way, you are unable to be intuitively convinced by arguments about, for instance, social goods or people suffering. You have no preconception of people's underlying rationality or the importance of particular actors like the market that should override your intuition about those things. Now judges are instructed to consider that intuition that they have as a bias that they ought to question and enact it in a conservatively economic way. Second, they're less knowledgeable about any particular economic theorem now, probably. Maybe they have some economic knowledge, but we can't assume that in this case. As someone, you expect, with no particular economic lens which you're utilizing, you expect lawyers, when they make economic arguments, to fully demonstrate their argument and fully take it to its analytical conclusion. Now that you've been given all this shorthand, now that you've been instructed to have this particular economic lens, you allowed lawyers to use shorthands to make particular arguments, and you find those more persuasive. And thirdly, I just say socially, this was a hugely extravagant crash course. 3 weeks where you go to luxury hotels and you get lectures from some of the elites in law and economics. So you obviously had a social incentive to listen and probably a cultural incentive to be respected by your colleagues by also listening and enacting the same kind of ideas with them. So having all those premises established, this led to a conservative bias on the behalf of judges, which had 6 consequences, which we think overwhelmingly carry us this way. The first is judges are far more likely to be punitive when they make sentencing. This is because they were taught to believe that people's cost-benefit rationality makes them commit crimes, which makes them fundamentally less sympathetic to people who do crimes because they believe that they did so rationally. And they believe that if you increase the deterrent on a crime, you can increase someone's likelihood to not do that crime in the future. The problem with that is twofold. Firstly, it's not true because people aren't always rational when they commit crimes. People do many crimes due to things like desperation that are not able to be rationally explained through neoliberal economic theories. And so this makes you far less sympathetic to that idea. But secondly, it's worse for people when they spend more time in prison because the prison system is not effective as a deterrent. So increasing people's time within that system is not useful because you strip them from their attachments to their community. You attach them to criminogenic networks that they find in prison that actually make them more likely to commit crimes. So more punitive sentencing is a bad thing. Secondly, judges are now more reticent to intervene to break up monopolies and allow more mergers to happen. Because they're taught about the benefits of monopolies, they now are far less reticent, for instance, to intervene to stop a merger or to break up a monopoly. Because they, for instance, believe that the threat of entry is actually a problem. The problem with this is that it's not true as well. The threat of entry is often really low because it's very difficult for a new entrant into a market to compete with a monopoly that has a super profits and has a monopolization over lines of production. Monopolies are terrible for people. The protection of them has been disastrous because monopolies without competition can gouge prices and exploit people's inelastic demand. For instance, think pharmaceutical markets where people are paying hundreds of dollars for insulin that is a necessity for them to live. Monopolies are terrible. Thirdly, you're more vulnerable to being lobbied by business because this economic course has made you more favorable to their interests. So you're less likely to rule in the favor of workers who are complaining of workers' rights abuses because you're more likely to believe that Amazon has economic and rational interests. Fourthly, you're more likely to defend its intellectual property. Why? Because many of the neoliberal arguments for intellectual property say that it helps you be profitable and that's ultimately beneficial. That's bad because ultimately patents restrict access to competitions, and in many industries, for instance, the pharmaceutical industry, have allowed monopolies to form. For instance, again, leads back to monopolies of things like insulin. Fifthly, you're more likely to rule that union strikes are illegitimate. Why? Because you support the free market idea that businesses are fundamentally rational and they will act. You do not feel like strike intervention is legitimate, so you're more likely to strike those things down, even when they may be legitimate. We say that's the principle wrong. And finally, you're reticent to intervene to prevent the negative externalities of things like fracking and things like oil extraction because you believe that government should regulate it and that the legal system should stay out of it, which has led empirically to companies being far poorly regulated. All those harms and more carry us to this debate. Proud to affirm.
Hey, thank you for that speech. I'd now like to call on the first speaker of the negative team who opened their case.
Hi, everybody. Just checking that I can be heard and seen.
Yep, you can be heard and seen.
Thank you. Give me just 1 second. Okay, beginning my speech in 3, 2, 1. What this affirmative team does that's great for side negative is they pin all their hopes and dreams in this debate on the idea that the only kind of economics that was taught in this program was neoliberal, was rational consumer hypothesis type stuff. What I'm going to demonstrate to you is firstly why this contingency cannot work for them in this debate, and then I'm going to talk to you about why we think this will be done particularly well, why there is a need for this in the legal system, and lastly what the future looks like in our world. So let's start about this, right? Oscar gives you like a couple of reasons to believe that this was neoliberal, that this came from like a neoliberal lens. I think the first thing to note is that this is a relatively empty argument. Oscar at best just kind of says this was taught neoliberally and doesn't really provide any reasons as to why that's true. The only thing they say that actually works here is that like Milton Friedman was a part of it, but note the topic slide says world famous economists like Milton Friedman, right? It doesn't mean that Milton Friedman was the only one there. And thirdly, it completely undercuts that this was the time around Mann's program. This was the time where doubt of the rational consumer hypothesis was forming in economics. This is the time where things like green GDP was starting to form, and where the very kind of criticisms that Oscar offers you of neoliberalism were starting to permeate into the field of economics, where things like political economy was becoming more important, and like fundamental questions in economics were being challenged, right? So what that should tell you, panel, is at the very outset of this debate, the vast majority of their material is at least doubtful, because it means that like obviously all of that is dependent on proving that the rational consumer hypothesis was the dominant form of economics. And we would note to you that it really has never been the dominant form of economics since the 60s. This happened much later. You ought not believe, the lies that they spin. They then tell you a couple of interesting things, right? They tell you that this teaches things like cause theory and, like profit and utility maximization. We think that firstly, and I will get into this further with substantive, but Cause's theory is not like the harm that they say it is, right? It is the idea that you should be allowed to negotiate. But even secondly, if you think that it is not incentivizing over regulating isn't like the thing you want, that is the status quo in the legal system. The legal system already incentivizes people to like do the things that they need to come to private agreements and things like that, right? I think the most persuasive thing Oscar then tells you is that this might have a harm in the court system because like lawyers might be able to just like use shorthand. I think that doesn't change anything, right? I think that this is an unfair argument simply because burdens of proof in cases don't change. Like what is persuasive to a judge in a legal context will not change here. So at the end of that, I think it's particularly clear that the vast majority of the material does not stand. Firstly, let's talk about why this will be done well. Firstly, I think the judges are pretty smart. Like generally speaking, they have quite a few degrees. Like in the United States, for example, they have to get a master's degree. Often they also have ancillary master's degrees. Which means that they're probably very well able to weigh knowledge, right? They're not just going to like take in all this economics jargon and be like, oh my God, wow, I'm an economist now, right? They're clearly going to be able to do this. Secondly, they have a long history with the law. A lot of the time, federal judges are quite experienced. They have a lot of experience in lower courts and things like that. Thirdly, they probably have some interaction with social science. They probably studied some form of government and economics at university in their undergraduate degree. That means that they're probably able to take these ideas with grains of salt, and they're probably able to look at things critically. Secondly, we know that this is like something that judges opt into. Obviously, those judges want to learn. And thirdly, this is probably going to be taught relatively well. Firstly, because it's like, highly effective world-leading economists that are doing this from both sides of the political spectrum. But also secondly, that like these people have been professors their whole life. They know how to engage critical discourse. They know how to engage critical debate. That is something that is going to be done well. So at the end of that panel, you should believe that this will largely be something that is done in good faith and done relatively well. It's not going to be the conservative shitstorm that affirmative needs you to believe for their case to work. Secondly, why is there an actual need for this in the legal system? We would note, firstly, that the law sees things as exceptionally black and white. It sees things as exceptionally immovable, right? So, like, for example, in property law at the moment, in the Torrens system, which is largely the case across the West, including most US states, right? The first claim to a property wins, right? So there is no degree of ability for you to negotiate where property claims are in conflict. There is just a black and white solution that doesn't take into account all the possible nuances of that situation. And that's where certain things like Cause's theorem and the maximizing utility and things like that do actually work in this context, right? Because it allows the court to give those individuals power to negotiate over certain things. That means that even if you believe that their neoliberal characterization is true, this is obviously fine. Secondly, we would note that things work a lot of the time in legal systems through precedent, right? So that is to say that judges, like in the past, only care about like what lawyers or previous judges thought. There is like very, very little multidisciplinary discourse in the legal system. We think that like more diversity, even if it's just at this point economics, is probably a really, really good thing. We would also note that judges often create laws by critiquing each other. So even at the point where only a few judges are doing this, they're able to critique the economic reasoning of other judges where that happens in the law. At the moment, the only way they can do that is from self-reference and from like what previous judges have thought. That is obviously not good. Thirdly, I would just note that law reform is just quite shit, right? Like law reform is very dominated by the legal profession. It is very slow moving, and it often doesn't take into account other perspectives very effectively. So for those reasons, it's quite clear that this is needed. Fourthly, there is a massive imbalance over property rights. And note that this is important, right? Because it's literally the entire affirmative case, right? This means that companies like Google and stuff like that can like manipulate property rights. If courts have a more understanding of like, you know, things like utility and cost benefit, they are more likely to be on the side of like people who are being undercut by the legal system, only because it allows them to consider the ways in which these things are harmful. Perhaps another example of this is looking at the concept of market structures and like monopolies, right? At the point that lawyers have a better understanding of the actual harms of monopoly and aren't just looking at it like a straight property right, like, you know, like you are Amazon, you have the right to do this because you are a private corporation, and private corporations in common law have been able to do this forever and ever and ever, right? They are now able to actually compare the economic harms of like Amazon being able to own the marketplace while also put things in that marketplace using the data it gains from it, right? And what that means is that there is probably going to be a more holistic understanding of these cases when they come before courts, as they often do. So what are the impacts? Firstly, we acknowledge we may not get instant change. We think some change over time is better. Secondly, these people are still judges. They're still able to draw on like a variety of knowledge. And then lastly, even if you believe even if you don't believe like that we get the impacts that we claim we do at the level we do, there is clearly still some possibility of change, and that comes up and above the affirmative team, who would just have the legal system remain the exact same way it was. No panel, that was their setup. So lastly, why do we think that this is probably going to get better in the future? I think the important note of framing here is that you obviously just don't regret the existence of the criminal justice system, even though it has flaws. You obviously don't regret things like criminalizing murder, right? Because you know that we can make things better over time, right? So why is there incentives to improve this? I think the first thing to note here is that like the demand for this program is likely to improve at the point it continues, right? Like it's more and more likely that as judges start doing this, they're going to see like better discourse coming out of other judges, discourse that they want to match or compete with, and that is something that, you know, like judges obviously have an incentive to do. Secondly, I think that there is like a lot of attention in the legal community that will be drawn to this. At the point lots of judges are doing it, it's something that people will talk about. The legal community is extremely insular. That's something that people are going to obviously like discuss and debate, and that's going to be something that like brings people in just on the basis that they know people doing it and they want to be part of that thing too. I think also probably point to all the luxurious things that Oscar tells you about, like how wonderful doing this is. Not sure why that was particularly bad, but sounds like it'd be a good reason to do it. Thirdly, I think that like the people who are running this program are obviously professors, right? Like they're people who have quite a good name in economics. And I think that what that means is that they probably have incentives to create a really good course. They don't want something to be shit, particularly when they're dealing with a powerful profession like the legal community. But fourthly, I think this opens the door for other initiatives, right? It opens the door for like other social science disciplines to come in, right? And like while we acknowledge that this may not be something that like, you know, is necessarily certain, it's something that we can at least get because there is a foot in the door in our world. Notice that on side affirmative, that doesn't happen. The impact of this panel is even if you don't believe it is good now, the chances are that it will get better in the future. Even if you believe, Oscar, the chances are it will become less neoliberal in the future. The chances are that it will be open to debate, open to discourse, done in good faith, and make the legal system better. We oppose.
Right, thank you for that speech. I'd now like to call on the second speaker of the affirmative team to continue this debate.
Can be heard? Cool. Unfortunately for that negative team, the last 2 minutes of that speech are completely nullified because this program no longer exists. So that means that they can't make arguments about how it will get better and it will get more progressive and more people will know about it because it was a conference that happened in the 90s, around the time when RBG was still a Supreme Court judge and was getting her start. This is obviously no longer the case. This happened in the past. We are regretting it happened in the past at that time, which means the arguments we make about how it's led to a conservative tilt aren't because it still exists. It's because it changed the culture of the courts fundamentally at the time when it happened. That means that those arguments cannot stand. This thing empirically no longer happens. We don't need to prove that it no longer happens because, as stated in the info slide, it just does not. I'm going to do 4 things in this speech. Firstly, I'm going to talk about what type of economics are taught. Secondly, I'm going to ask if it's done well. Thirdly, I'm going to ask if there's a need for it. And finally, I'm going to whip some impacts about what the actual conservative implications of this policy are. Let's start with thinking about what types of economics this conference actually taught, because this negative team seems to believe that it was not just neoliberal economics. In fact, there was a vast variety on the political sphere that were taught. The first response is that this is actually just empirically untrue. People like Milton Friedman were the reason why people went to these conferences. Like, the draw card was the fact that the neoliberal masterminds of the day were leading these conferences. But let's put that onto one side and actually debate the reasons why it was neoliberal. First of all, neoliberalism still is the most overwhelmingly popular type of economics. The reason that's true is because it is still the type of economics that is taught in any undergraduate university degree across the entire world. But at that point, that was even more true. Chris says, well, that was the time when things like political economy were in their inception, and there was more, anti kind of rhetoric around neoliberalism. That's a fallacy, because at that point in time, that is when things like globalization and the technology boom were starting to happen. It was the turn of the 21st century when people were becoming incredibly neoliberal pilled because they realized things like the benefits of free trade to them. They realized the benefits of being able to travel for low cost. They realized the benefits of international collaboration for things like bringing prices down. So unfortunately for this negative team, maybe it's true that now there is a resistance to neoliberal ideology, but certainly in the 90s there was not. And even if there was a little bit, there certainly was not in the sphere in which these conferences were operating. These conferences operated with people who were incredibly wealthy and privileged all coming together. And that necessarily means that neoliberal ideology was the one that was dominated, because that is the background that these people had come from. They had been educated in Ivy League institutions that teach neoliberal ideology. They teach things like supply and demand and market forces being the answer to everything. Second of all, let's ask, are these conferences actually done well? Because Chris says things like, well, judges are extremely smart and they have a history with the law, and that means that they can take things as they come and go. So some things they can believe and other things they weren't. First of all, the way that these conferences were taught as they explain themselves is by people who were extremely famous and had a huge amount of reputation in that economic sphere. And that necessarily means that it's highly unlikely the judges are going to take these things with a grain of salt. Because as soon as these people come up on a podium and say that they have a first-class honors in economics, they've been teaching at Harvard for 30 years, and that they literally wrote the book on laissez-faire policy, you probably don't take the things they say with a grain of salt, because they have so many resume-style boosters to help themselves. That means that you probably take them extremely seriously. But second of all, even if you don't buy that, the stuff they were teaching just makes intuitive sense. The reason why supply and demand arguments are so easy to buy into is because they are easy to understand. That doesn't mean that they are good. They actually have a huge amount of negative externalities, which will tell you at Oscar, but it does mean they're intuitive for the average non-economically educated person to opt into. And that means that there's actually a very low chance that these individuals question them, because by their own analysis, they have a history with the law, not a history with economics, which means they will buy into this kind of rhetoric and policy. They've already opted into the conference, and that means that they have an interest in learning. Again, we can literally use all of that opposition team's analysis against them. They have a history with the law, they opted into the course themselves, and they are smart individuals. All of that means that they know these people that are teaching them are qualified professionals. They understand the things they are being taught because they are smart, and they opted into the course in the first place, which means they are there to learn and not, in fact, take it with a grain of salt. Maybe that's true if it's compulsory, but it's not. But also the kind of judges that are taking them are already highly selected by virtue of the fact that they have become federal judges. Next, let's ask, is there actually a need for it? Because Chris says things like, well, the problem is judges rely too much on precedent and take things too black and white. I think this is probably the silliest stuff. Because first of all, by their own analysis, judges are incredibly smart, which means that they are able to do things like detect nuance because they have a huge amount of law experience. But second, and more importantly, on the stuff around black and white, this I think is so silly because economics is literally black and white. If you care about understanding nuance, you won't teach lawyers and judges that laissez-faire economics is the answer because it is quite literally the most black and white doctrine of economics. It tells you that the market price will be optimized at the point at which demand meets supply. It tells you that monopolies are okay because there is always a threat of entry. It tells you that individual landowners should have the choice. All of that means that it is an incredibly black and white system that says individuals good, government intervention bad, individuals rational, regulation bad. That is inherently black and white and allows for very little nuance. Finally, on precedent, I am unsure why they think precedent is bad. Precedent is the reason why judges are not able to get over doing extremely corrupt decisions because they have a law which they can follow their decisions in. Cases are incredibly complex and having some form of precedent on which you base your decisions is incredibly important because the law should be something you are able to trust. It is something that has been used for history and generations. Without precedent, the system absolutely crumbles. Finally, I'm going to whip 4 impacts that Oscar talks about, which is how this economic policy trickles down into more conservatism, both within the justice system and out of the justice system. Firstly, on sentencing, this conference made sentencing far more punitive than it ever was because it gave you the rationale that you commit crime with a cost-benefit calculus, which means that at the point at which you've committed a crime, you yourself have rationally opted into that crime because you are maximizing your own benefit because of things like Milton Friedman economics. But the problem with that is that it's often not true people are rational when they opt into committing crimes, particularly more marginalized and vulnerable individuals who often commit crimes out of necessity, which things like this economic policy fails to account for. Secondly, on things like monopolies, these policies argue, rhetoric argues that monopolies are good because there's always a threat of entry, because they optimize price for consumers, and because they increase access. That's obviously untrue. It's proof that tech monopolies and grocery monopolies are terrible for individuals. They're able to do things like price gouge. They're able to completely control all of their supply centers, and that's bad because it means the individual has no choice. Thirdly, on intellectual property, it means that patenting becomes far more easy because you optimize. But finally, it makes regulation and unions incredibly difficult because they think that the market should have complete control and the government does not matter. At the end of this speech, this was something that judges opted into, which means they wanted to learn, which means that they listened to the neoliberal rhetoric that they were being poured into. We obviously all regret this.
Alright, thank you for that speech. I'm now to call on the second speaker of the negative team to continue this debate.
Can everyone hear me? Okay, starting my speech in 3, 2, 1. I think the issue with this affirmative team is even if you buy that only neoliberal economics was taught at this event, which it most certainly wasn't, you must buy that there were different types of judges there, and the development of law is not just single judges making judgments. It is critique, it is different types of judges making suggestions. And when you note this is an opt-in event, so there were judges who did not attend, who weren't swayed by this, that means the influence of the judges they claimed wasn't as severe as it was. What this economic policy actually did, however, was allow in particularly niche cases of law where common sense and legal policies weren't enough, allowed another barrier of analysis. It was another tool in the toolbox for which they could analyze things, even if you buy that maybe this analysis was slightly neoliberal, that it was slightly towards monopolies. We think that this extra tool has cases where it was useful, and that was a benefit it was striving towards. 3 issues in the speech. First, how do judges react to this? Second, was this program taught well? And third, what are the harms and benefits that each team proposes? First on how do judges react? Because I think the mechanistic issue with side affirmative is they tell you that all of these judges believe them because they are famous people, but I think this ignores a few important things. First, 5 responses here. First, we tell you that this was opt-in. The reason why this is important is that means that legal issues which developed by systems of legal critique, by law journals, that means that even in the best version of the world, where everyone who went to that conference suddenly became a neoliberal-minded cuck, suddenly they weren't suddenly going to be able to change the law as dramatically as they said, for the reasons they give you that people opted out of this. Second, we tell you that judges are intelligent. I think Bella misses the point of this argument. The point of this argument wasn't that, oh, they believe more intelligent people. It's that they have the intelligence to discern and weigh issues themselves. So yes, maybe they are taught that monopolies are good, but people like RBG, who are very much against neoliberalism, and note, the motion issue literally says that there are liberal judges there and conservatives, so that you must buy that there was obviously people who disagreed with that sentiments that were presented, they were only neoliberal. And that means that obviously there was not just the uniform perspective that they gave you, which means that wasn't just going to result in people leaving that conference and be like, oh my goodness, I love monopolies, I'm really going to like screw over the average person. Of course it didn't. Third, we tell you that judges actually rely upon legal frameworks more, and they only utilize this in niche cases. This is incredibly important, but this is just true for the reason that if you are a judge who has spent 30 years practicing and you spend 2 to 3 weeks at an economics conference, that means you're not going to apply that in every situation. You are still going to rely upon precedents that were established before neoliberalism became a thing. What we are saying is that in the niche cases where precedent is insufficient, maybe you have an extra tool in the toolbox to do things with. Even if that results in sometimes worse outcomes, which I don't think actually occur, we think there are a series of net benefits. When Coase theorem allows for property rights to be changed, for example. That is a benefit which they refuse to engage with. Perhaps there were harms in the best version of the world, but there are a series of long-term gains you get. And noting especially when you note that the development of the law is particularly problematic, there are still issues with the law at the present in non-economic issues. You must note that problems with the law existing is insufficient for them to prove this was regrettable. They needed to prove that this resulted in systematic long-term harm that would never be solved. Fourth thing we tell you that this is incredibly marginal for the fact that judges already have biases. The info slide says they are federal judges. The implication of that means they are quite old. They already have biases that they were formed in the first 30 years of their legal career. It's deeply unclear why their views were suddenly changed. Even if it was a famous person, if you've been practicing law for 30 years and you've already gone through the federal system, unclear why you suddenly get shifted so dramatically. The reason why this is important, and finally, the best response, one of the better responses I think we have as well, is the fact that the comparative is worse because it creates bubbles, right? The alternative is you have neoliberal judges just talking to themselves about economic policies and getting stuck in their own chambers, whereas conservative judges just get stuck in their own chambers. At least in this conference, if there was one judge, if there was one panelist who didn't talk about neoliberal things, that would have broken the bubble to some extent, maybe allowed for new perspectives, maybe allowed for new thought. The reason why this argument is important is because Bella spends 4 minutes of a speech proving why the ideas taught that were neoliberal. We say this doesn't matter because the way that judges interpreted this information wasn't they just believed it automatically. It was they thought about it rationally because they've been practicing for 30 years. As they tell you, they already had biases and they weren't going to use this in the everyday scenario. It was going to be an additional tool that was going to help enhance the legal system. I'm going to move into the second issue. I'm going to be rather brief with it because I think the simplest response to that stuff on this program being entirely neoliberal is just a little bit uncharitable because I think it's the best version of the world where all the material there is neoliberal. Unclear why that was the case because surely you have at least one panelist if it's a 2 to 3 week conference that isn't neoliberal, right? Like I know this is an intuition part, but it's just absurd for them to claim that the only thoughts they were neoliberal. Like I think that just doesn't pass intuition. The other pushes here are just like, oh, it's neoliberal because it's the 1990s. We know there's this degree of social reform. Bella's response here is that this conference only occurred word want. We tell you why the social reform is important. It's because it shapes how judges perceive this information. Because even if you have the best version of the world where they suddenly believe this is all true, it's unclear when all of this background noise is occurring, why they would just believe this hook, line, and sinker. So what you must buy then is that this issue was less important. The fact that a firm that spends so much time on this is unstrategic. It's more important to prove how judges react to it. And at the point where we prove that judges, at least a few of them, because note, we only have to prove a few judges don't react to this, because that is how legal critique works. At the point where a few federal judges disagree, even if it's just one or two, that is sufficient enough for us to actually show that these policies are not overwhelming. We have already met that burden. That's why it wasn't going to be as overwhelming as they said it would be. And that's going to deal with a lot of the issues and harms. Because the first thing I like to establish is that a lot of the harms now is first uncharitable, because neoliberalism actually doesn't teach about monopolies. It teaches about reaching perfect competition. That is how neoliberalism works. It's just teaching the idea that you deregulate markets and lower barriers of entry so more competitors can enter. It's not about monopolies necessarily, but let's avoid definitional disputes. Let's just do the best case. First, we've shown you that it's unlikely to culminate in the harms they tell you, because there are still a few judges who do not opt in. So even the best case where everyone becomes a brainwashed neoliberal zombie, it's deeply unclear why there's judges who didn't go to that conference would suddenly become the same type when they could just stand up to them. Second, I think it's wildly asserted that they just buy these ideas, because it's just like, as a judge, if you are the one who suffers from pricing issues because you support laws that have monopolies, surely you realize you've messed up somewhere, right? Like, surely you have enough common sense. We don't think this results in massive law reform, as they tell you. We think it results in marginal changes when there are very niche cases. You allow for slight increases. That's incredibly important. Our third response here is to say that it's incredibly difficult to change the law because there's precedent. This precedent was established prior to this. This means that you're unable to change it. The reason, however, that we are able to get change is because on our side, you introduce more ideas. You introduce more change of thought, because the comparatively we must defend is a legal system where literally in torts, they do valuations by common sense, where they often just utilize an incredibly arbitrary way of doing things, such as doing first to the post for property rights. That was a system which wasn't great and one we would like to reform. The way you reform that is by adding economic ideas through policies which are through conferences which are large and famous. Note, they might say, oh, we're showing you why judges don't care. The reason why they do care to the smallest extent is because at least they make more considerations. They make more considerations, even if it's a back thought. That back thought never occurs in their world. At the point where we show you one law improves, that's the case that we win. Dealing with quickly in the material on lower CS, I think it's unclear why lower CS people are implicated, because we tell you precedent applies to lower CS crimes. That is to say, they didn't commit the crimes that result in groundbreaking change. They commit crimes that would already set in rules in 1930s. Unclear why they were the major victim in this debate. I'm so proud to negate.
All right, thank you for that speech. I'd now to call on the third speaker of the affirmative team whenever they're ready.
Hey, can I be heard? Sweet.
Yep.
You should read the article in the UNSW Law Journal that literally does a statistical analysis on how this economics course has affected the rulings of judges in the federal court. And it is truly shocking if you read it. It literally says a whole bunch of things that are pretty unsurprising, right? Like, you teach some judges some neoliberal economics, and who would have guessed it? They kind of support a couple more mergers. They kind of support, let's extend this intellectual property. They err on the side of businesses. But then it starts getting more and more concerning. It starts to describe how this seems to have flow-on effects to environmental decision-making, how they seem to become a lot more pro-mining lobbies. Then it seems to flow on to unions and their decisions on when to say a strike is illegal or not. Then it seems to flow on to even the sentencing of criminals on the ground. And ultimately, our case was, this shouldn't be a surprise, because the more you tell a judge that this person is a rational actor, they're making an economic decision when they're stealing this loaf of bread, how many years in prison am I going to occur versus the benefit of this bread? It should be no surprise at all that the intuitive, empathetic, and very human argument, arguing that this person is desperate, this person is irrational, this person is not making an economic decision, that argument lands less strongly. And that is why this team just receives a set of conservative economic policy, both socially and economically, which is a harm. And they seem to not recognize that their own strategy, their own case, is trying to prove that these judges have more information to make more progressive economic policy. And it's an impact that they conceptually try and claim, but never step through how this policy actually eventuates. Because if you listen to that prior speaker, they emphasize so heavily, this is an extra tool for these judges. It provides them more information. And that is just assumed to be a good thing. Like, they don't explain how this extra tool leads to more progressive or helpful policy on the ground. This extra tool leads to them being more conservative, and that is a harm, and that is our case. So why is it first? And like, both teams are trying to reach this golden benefit of how does this economic and social policy and rulings change? And there are kind of three questions that instruct how that policy changes on the ground. First question is, and perhaps the most important question, is this taught in a neoliberal fashion or not? And I think the opposition team just needs to be reasonable with us here, because it just intuitively, empirically was highly neoliberal. But their responses here, I guess tellingly, are not particularly strong. When they say things like, the criticisms were starting to permeate at the time, there'll be a little bit of non-neoliberal stuff. The problem is that the established economists, not the people that, were like listening to this criticism in universities at the time, but the genuine people like Friedman, who were Nobel laureates, were the type of person that had spent decades of literally believing in neoliberalism. And it wasn't enough to just be like, oh, it's kind of starting to emerge here, but they need to prove that the established professional individuals that were highly respected to be teaching federal court judges, this is what economics is, were the type of person that was listening to that criticism. But the second response is, this was just a while ago. Like, these courses were in their infancy. There was way less data of counteracting neoliberalism. There was way less proponents and leaders against neoliberalism. It was far less accepted that neoliberalism was wrong because there hadn't been the GFC yet to say, hey, maybe something is wrong here. And that is why this program was temporary. It couldn't be reformed. It just happened. And most importantly, it was overwhelmingly neoliberal. I think we win that question hands down. Second question, which they contest much better, is, was this genuinely really persuasive or influential of these judges? Did these judges believe it hook, line, and sinker? And I want to immediately know, we don't need to win it by anywhere near as much as side opposition says. Like, truly, listen to their weighing. Their weighing is like, even if 90% of judges believe more neoliberal economics, that's all right, because the remaining 10% of those judges apparently are going around critiquing the increased sentencing that they give, or critiquing the fact that they said this strike was illegal and this union shouldn't have this power magically. Like, no explanation about how this critique occurs, why it's effective, why it's in judges' incentives to critique other judges, why this is in any meaningful way a legal norm. But more importantly, is substantively in our case, we explain that, yes, these judges are relatively educated and they are somewhat critical. The problem is not, do they have the capacity in their brain to be able to critique economic knowledge? It's, will they? Do they want to? Do they genuinely listen to Milton Friedman and say, this guy is an idiot? I actually think this economics is wrong. It's implausible because the course is framed as fact. You're not framing this as like a philosophy lesson where we're discussing ideas and critiquing things. You're framing this as just genuinely, this is information that will be useful for you to make economic decisions and make your rulings better. It is framed as something that is objective because that was the times. But secondly is, you have to believe that these judges are more confident than people that are incredibly well educated as well. You can be really smart in a legal degree and be very educated and still have very little economic knowledge or understanding of how those things work. It's incredibly likely they believe this information and they see it as fact and are unlikely to be deeply critical. But their other analysis is, but you opt in, which is exactly why you're incredibly receptive. You kind of want to take this information on board. And their other analysis is, but they're well-leading economists, etc. And as we explained at Bella, you're just not exposed to alternative schools of thought. You're exposed to something that seems pretty intuitive from the get-go, that has a huge reputation or name, which means even if you don't believe it hook, line, and sinker, it still very much subconsciously affects you to kind of believe that that is just true and that is economics and how it works. Third question then is, Okay, given that these courses are relatively neoliberal, that judges relatively believe them pretty sufficiently, how does that actually change their decision making? And I'll immediately note they choose not to respond to analysis being like, this makes arguments on empathy resonate far less deeply. They choose not to respond to analysis being like, judges become less open to new forms of information because they're not a blank slate where they're uncertain. They now already have a preconceived notion that this form of economics is correct. And their argument, finally, is to just be like, oh, the burden of proof is the same. Yeah, the question is it easier to reach that burden of proof with a judge that is familiar with the keywords of the lingo, has these preconceived notions that this form of economics is correct or not? It's clearly much easier to reach that burden when they've been through this economics course. What that means is, yes, there will be some critique of precedent under both sides or whatever. The question is that critique more or less likely to be progressive or conservative when you've been through a neoliberal economics course, unsurprisingly worse under their side? Last question then, what are the impacts of this? They write a huge amount on a very poorly explained analysis about supposedly Coase's theorem is going to help property rights here when we make the argument that the way that property rights have been interpreted by the Australian legal system at federal court is that they argue, I control this property, I own this piece of land, therefore, the government should pay me if they want me to do things that are good for society with it. The two great examples of this in Australian law are firstly, the water buyback scheme. It is where we said to farmers, yes, you own your property, the rain that falls on your property, the government's going to pay to make you release that water back into rivers. This is incredibly problematic because it is so hard for the government to get up there and spend hundreds of millions of dollars for something that is good for the environment. When water is obviously a public good, they should be made to release that water. They should be paying the government for the water, not the other way around. That is why Coase's theorem is squarely under our side. But secondly, is the example of deforestation on properties. It is that people say, if you want me to not deforest this punch a wilderness on my property, again, the government should pay me. And that was why this was so backwards. Not to mention, we proved not just on property, but on so many other facets that go unresponded to. We explained this affects social policy, from sentencing to people on the ground, of labor laws and strikes that now go disallowed, from intellectual property, which is now extended for longer periods, and monopolization, when you get more mergers and you get less antitrust enforcement. All of these are economic and conservative economic policies, which are harms that opposition bears.
Okay, thank you very much for that speech. I'd now like to call on the third speaker of the negative team.
Okay, I'm going to assume I can be heard and I will get started in a couple seconds. There's a key contradiction in this affirmative team's case, where they simultaneously argue that this program was so influential that judges radically changed the way they sentenced, but also that it happened over 30 years ago, over a couple of weeks, and therefore is not going to be developed into the future. Eugene gives you a bit of new material on this in terms of, well, there was an article in a journal that talked about this, and just intuitively, empirically, it was neoliberal and incredibly important. I think it is probably fair to say the average reasonable voter did not read this article and does not know what happened at this weird conference, and therefore has no way of knowing if this assertion is correct or not. Both of these things can't be true in terms of how influential and low impact this conference was. I'm going to assume that it had some long-term impact. So this debate actually matters and had impacts. If it is lower impact than I say it is, it simply symmetrically means that both teams have smaller harms and benefits. And this is our first pathway to victory, where we absolutely eclipse the other team when we talk about the future potential of this program. Because no Chris tells you at first, no response, that this program provides a foundation and building block with clear incentives to improve it, which are four main ones. Firstly, there is clearly a demand for this program and people want to increase demand. Secondly, it leads to attention in the legal community. Note that is something that is backed up by AF's analysis, where they say that it significantly changed the way the legal community thought and sentenced. That suggests our analysis is correct. Thirdly, we tell you there is the potential to be beneficial, and economic experts care about their reputation and judges' understanding. And fourthly, it starts a trend with better actors who want to make this a better process. The impact of this is that even if the other team proves it's poor in the status quo, we provide you with clear incentives why they get better. And what this uniquely does is deals with the affirmative team's worst case scenario and tells you why we still win under that.
We only get one response from this at second, which is, oh, this conference was a one-off thing. But as I've already told you, that simply means they cannot claim any of their harms in terms of how it changed judges' minds and sentencing. Because it was a one-off thing, how did it change people's opinions on unions and workers and monopolies? There has to be a concession from this team that had some long-term impacts. It's what their case is built in. The fact that this debate is set at all suggests some reverberations and long-term impacts, and that this set a kind of precedent. Even if you do not think that our argument is as strong as perhaps we argue it is, it exists in this debate. It was never actually engaged with by the other team, and it provides us one unique path to victory that deals with their worst case scenario. They never respond to it in the way they needed to. Let's deal then with the main question in this debate, which is whether these programs are good or bad. And I want to note at the outset of this that a lot of the affirmative team's analysis is contingent on something they don't prove, which is that economics is going to be the most prominent issue in the mind of a judge. That a judge who's gone through decades of legal and other training is now, when they sit down to make their decision, going to chiefly think of this 2 to 3 week conference and what it taught them about economics. That was something that was never proven. We give you structural reasons why previous, not generational, but decades or year-long biases are probably going to be far more powerful and overcome that short-term education. That is something that seriously cuts down the level of harms they can argue in this debate. But I think they tell us 3 main things under this issue of why the program is bad. Firstly, that it's neoliberal economics, which is bad. Chris tells you 2 things in response to this. Firstly, that it's based on one example from the info slide. And secondly, the program was created at a time of criticism of these neoliberal policies, at a time where things like climate change and concern over monopolies was incredibly high. We hear one response from second affirmative, which is just neoliberalism was still the dominant thing, and this is reiterated by third. But note that this is unresponsive to the idea that there were obviously still challenges to a dominant form of economics. As Kevin tells you, even if only a few lecturers or presenters presented things that contradicted this, that is something that these judges heard, that is something they are likely to have cared about and heard. So I think, even if neoliberal economics is taught to some extent, it is absolutely not the only thing taught, and we're going to explain to you why, even if it's a thing that's taught, we still win the debate. The second thing I tell you, and this is where they seem to pin a lot of their hopes on winning, is it encourages judges to make really poor decisions on things like anti-union and worker stuff. 4 responses to this. Firstly, I think, like I've already said, they don't prove why economics education, which they construct as this short-term thing that happens for 2 weeks and everyone's forgotten about, is going to be the most important information in your mind when these cases come before you. We would argue that judges, due to their long experience of being a human, know that a human being is irrational. And to the extent that one old white guy told you over a week that humans are incredibly rational robots, that does not overcome your lifelong experience of irrationality and emotions and feelings. The second response is, I think, to a really significant degree, the status quo is that judges are conservative and shit on workers and care more about Apple and monopolies. What this means is this argument is incredibly marginal at best, i.e. judges who are already biased against workers and care more about big businesses maybe make slightly worse decisions in their best world, but you need to weigh that against the larger benefits we give you of benefiting these smaller people, these people that I'm going to get into a little bit later. The third thing is that obviously this is in contention with their own analysis, that precedent is the key thing. It suggests that judges would listen to the precedent on how they should deal with unions, workers, monopolies, etc., not what Milton whatever told them on the weekend. The fourth response is that these arguments are simply in contention with neoliberalism in general. And this is where, even if they prove that these conferences taught neoliberalism, we can still win. And this is something Kevin tells you to no response. Because neoliberalism uniquely thinks that monopolies are inefficient because they overprice things. It thinks that unions are an important part of the system. And therefore, it is directly in contention with the consequences the affirmative team tells you come out of teaching those things. The final thing they tell you is that judges do not question this stuff. I would probably note firstly here that the entire job of a judge involves questioning shit. That is a pretty key part of their identity. If they just listened to what lawyers told them all day, the judicial system probably wouldn't work. We'd also note that judges, particularly federal court judges, probably have high egos and think they do know better than these random economics professors and that they're not the harbinger of all intelligence on the earth. The second affirmative also importantly concedes that judges buy nuance. That helps us. The unique thing that Kevin tells you at the end of this debate that receives no response from the third is that we say that regardless of if there are problems with this system of teaching economics, the counterfactual of nothing is worse. And what Kevin uniquely tells you here, again, to no reply, is that you have incentives to learn in either world. And in their world, you talk among your conservative buddies in echo chambers with no countervailing force, no educated experts who talk to you about like facts and statistics and like what happens in the real world. We would argue that any challenge, even if it is a small or minority challenge to neoliberalism, is preferable to kind of backroom echo chamber conversations that they have to concede happen in their world. At the end of this speech, I'm now going to bring you the clear impacts we bring in this debate, but again, don't really get a response from the other team. And they're threefold. Firstly, we tell you we get better law reform and note that the status quo locks out other disciplines in terms of things like economics, and that economics has important points to make that come to law reform, that can benefit law reform. That is something that does not get a response. The second thing we tell you is that judges have better understanding of market dynamics, things like Amazon versus a small institution, and they are less likely to give private companies the ability to do what they want. Eugene has one response to this, which is just an Australian example of water. Like, this debate is not in Australia. That's not a structural reason. That's an example of water. Anyway, the third benefit we give you is that you get better evaluation of damages for negligence, things like climate change, etc. Again, we get no response to this. At the end of this debate, what you ought by is that for this debate to function, for the other team to get any benefits, there were some long-term implications of this program, which means firstly, that it has future potential and incentives for it to get better in the future, something they never structurally rebut and only dismiss. And secondly, that even if it taught neoliberalism, even if we concede that, it is still beneficial to the counterfactual, which is getting locked in echo chambers with no one challenging these opinions. Thank you.
Right, thank you for that speech. I'm now to call on the neg reply to conclude their case.
Hey, everybody, just give me 2 quick seconds to sort my paper out. It's a bit of a mess. Okay. 3, 2, 1. 3 questions in reply. Firstly, will this be a neoliberal thing? Secondly, what are the benefits that we give you? How does that compare with the opposition? And lastly, how will judges react to this, noting that that is really just defensive material on the side of affirmative? So, firstly, will this be a neoliberal shit show? I think the first thing to note here is that the path to victory for the affirmative team necessarily relies on this. If we can show that this is probably not going to be neoliberal, all of their harms just die panel. Notice that immediately at the outset. We tell you a few things. Firstly, we tell you that there's likely to be a diversity of views. I tell you at first that this is probably charitable. They also give you structural reasons. I tell you that it's there was a lot of there's always been a lot of discourse and debate within economics. This is hammered down the bench to no charitable response. But secondly, we tell you that the context of the world at Kevin was one of climate change, was one of corporate takeovers, like things like US steel collapsing, was things like outsourcing, right? Was all of these kinds of important things. And the response that we get from Bella as to why it was neoliberal was globalization. Yes, globalization is precisely what caused all of these critiques to happen, right? But secondly, Eugene's oh, but people didn't think it was wrong. But this is again unresponsive to what we tell you, that there was always criticism in economics of this theory, right? So what this means is that at the end of this, right, what you ought to believe is that at the very least, there is some doubt as to whether or not their entire case works, right? Even if you don't believe it completely, you ought to believe that the weighing is much lower. Let's talk about the benefits that we give. Second question in reply. Firstly, we tell you that we get better law reform because there's more interdisciplinary access to law reform, which doesn't happen in the status quo. No response whatsoever. Secondly, we talk about market dynamics. We say that, at the point there is a monopoly like Amazon versus a small business, judges can better understand the impacts of that market economy beyond just private corporations can do what they want. No response whatsoever to that mechanism. It was given at first. They had so much opportunity panel. Thirdly, Kevin tells you that valuation of tortious claims and things like that, which is often how you sue for negligence in things like climate change and things like that, are better valued in our world because you can understand economic impacts rather than the common sense status quo that exists within tort law. No response to that whatsoever, panel. These benefits simply stand. Fourthly, we talk about precedent, right, and how that gets better. All Bella says in response to this is precedent's good. What we say is that precedent can be better at the point you have more interdisciplinary access. That was the benefit we claim. No response. Fifthly, we talk about the future. Their only real response to this is to be oh, but it ended, right? Notice all of what Annabelle tells you about how, if it ended and it wasn't that impactful and didn't have that much results, right? Clearly, their whole case just doesn't work, right? Because it just means that, if it ended, right, it can't have done all those really damaging things to the legal system. And Eugene's only way to rebut this is in introduction when he talks about an article that, most people haven't read nor heard of, right? Wasn't mentioned on the info slide. Get real. You have to talk about the average reasonable voter here. But we tell you that this is probably going to improve. But most notably, Annabelle tells you that even if this is true, like even if we only have like, this one-off thing, it creates the possibility for doing things in the future. That was said in my speech, no response panel. So what's clear at the end of that is that our positive benefits stand, their positive benefits are, I'll let you know when they come out at affirmative reply. So how will judges react, right? This is very, very defensive from them. We tell you that they're going to opt in, right? We tell you that there's probably not going to be a lot of judges, right? This is probably going to be something that is not over the top, right? We tell you that judges are probably able to critique this. They say, well, it's about whether judges will critique this. We say, true. Ruth Bader Ginsburg probably fucking hated neoliberalism, right? She probably had critiques about that. Liberal judges probably didn't take this as well. So at worst, conservative judges just become a bit more conservative, right? At the end of that, it's clear that that should not be persuasive in this debate, right? And then we tell you that obviously things like long-term experience in the legal profession, long-term academic experience and things like that are likely to be more prominent in the minds of judges. And if they are more prominent in the minds of judges, it's deeply unlikely that that is going to be the sort of thing that sways judges in this debate, right? It is probably going to be more likely that their arrogance, as Annabelle tells you, is going to be the most important thing. Briefly on monopolies, this was their whole big harm, right? Like neoliberalism hates monopolies. They think it causes inefficiency. This has been long established. We tell you this in 2 speeches, no response. Unions are also part of the cost of labor in neoliberalism. No response whatsoever to that. So at the end of this, what's clear is that this probably didn't have a terrible impact on judges that they claim it did. But even if it does, the benefits we claim stand. No response whatsoever from this very unresponsive affirmative team.
Okay, thank you very much for that speech. And now to call on the F reply to conclude this debate.
Audible? Cool. Question 1, what was taught and how was it internalized? This is where the negative team starts a war with the info slide. And Annabelle's core weighing in third affirmative is, oh, this happened once and then never again, so it's not important. Okay, it was a program that happened numerous times in the 1990s. It included many federal judges. It is now discontinued. Notice the word was in the info slide. You cannot reform it, you cannot make it better because it no longer happens, but it can clearly still be true that it happened for a large amount of federal judges in that time period. Clearly, it could still have been influential. We explain this debate the impact that has, that you get a set of highly credible in the time of the 1990s, at the zenith of the faith in free trade, in globalization, in neoliberal economists with Nobel Prizes like Milton Friedman, and you didactically teach federal judges their theories. At the height of charity, you might believe there are more heterodox theories like political economy and critiques of neoliberalism that are arising at the same time period. That's all that negative really proved. There's no incentive that's given by them that those alternative heterodox theories are included. They give no explanation of why you would have the incentive to include critiques of dominant theories within this program. If it is to be a didactic thing that helps you, that's unclear why. What's clear? Without this program, they defer to their intuitions far more often. For instance, like people might not exactly be rational when they commit crimes. Without this, they do not show an implicit partisanship to certain arguments that are proven to be mostly neoliberal in these programs. So question 2, the more significant one. Was this qualitatively a good or a bad thing? I think this is a great illustration of the problem with mitigatory rebuttal in debating. Negative insists in this debate that it wasn't all neoliberal and they don't buy in just uncritically. Maybe that's true. When you consider our harms and whether they carry, your question mustn't be, do 100% of judges leave this program uncritically neolib-pilled? It must be, on the balance of probability, did a majority of judges leave with more favor to neoliberal economic theories than they otherwise would have if this program did not exist? And this is clearly what leads to conservative legal trends that carry our harms in this debate. And if that's your question, it's far clearer to see that saying, oh, it wasn't all neoliberal, they don't all internalize it, doesn't actually defeat our claim. This is the part of the debate where refusing to engage with our harms is fatal. There's no attempt, or very little attempt, in negative speech to refute the core win con of our case, which is that judges enacting a preference towards neoliberal economics is bad. Firstly, because, and this is the one they never respond to, because it leads to the theory that you should do more punitive sentencing and have less sympathy to vulnerable people who maybe commit crimes of desperation. It is that you have more leniency to the structures of monopoly formation and restrictive intellectual property laws that lead to price gouging, lead to millions of people being unable to afford food or medicine. You are reticent to intervene to help environmental causes and labor causes, and they concede that all of these things are a result of status quo, which has a time problem, right? Like if this program existed 30 years ago, conceivably you would be seeing the consequences now. Observing the consequences now does not help them, it hinders them. They say that monopoly formation is opposed by neoliberalism. As I explained in first affirmative, that is not true because they make arguments about things like economies of scale and the productivity you can get with them. That is clearly a neoliberal argument that these programs would have. They have some claims to weigh against it, but even if you believe all of them at their full value, they just can't get over that. The first is you're more likely to question precedent. Unclear why that's an inherent good, but they've not thoroughly demonstrated that's a likely result of this program. They say Coase's theorem is good, but we illustrate in Eugene's speech that it's environmentally disastrous. It tells you that you should not intervene when actors are acting like freeloaders on public goods like water, which has led to environmental crises. They argue that you produce criticism, but that clearly doesn't get over it because 10% of people producing criticism is not the same as 90% of judges enacting that preference. The affirmative team have a win strategy, the negative team do not. You must vote for us.
Cool. I see that Naf and Neg are both here, so let's get started. First off, I want to say thank you all for what we both thought was a pretty good, high-quality debate. Okay, so 3 things in this OA. Firstly, on general feedback, secondly, on the decision, and thirdly, on how we came to that decision. On general feedback, the panel thought that there were 4 main things that we could talk about. Firstly, I think it was important that we are clear from the onset about the timeline on which this debate operates. That is, I think we hear clarity on it like towards the end, but maybe just be clearer on like from the very beginning on when does this conference happen, how often does it happen, how many times has it happened. And I know that the info slide does obviously cover a lot of that, but maybe making that clearer so the debate does not get messy. Secondly, I think we needed more, like we could have benefited with more discussion specifically to this debate on who gets to decide what is talked about at that conference and characterizing exactly what those people look like. I think that we did get analysis on what the people at that conference look like, but maybe on like the people who get to decide who talks as well. Thirdly, I think that we also, like when we're doing analysis, I think we're good at providing reasons why it's true, but also there were many major pieces of analysis from both teams that needed reasons why this was likely, or that is to say, like to be more charitable to the other team and accept that perhaps their alternative is something that may happen, but here is why our alternative is particularly more likely. And the fourth and final thing is that we could all do with a lot more specificity, especially when we're dealing with large and broad stakeholders. That is to say that, you know, not all people are homogeneous and not all people act the same. Obviously, like when you have a broad stakeholder, that stakeholder is likely to have multiple facets within it. So it is really good to analyze each of those facets and how they are likely to react and how they impact your case. On the decision, we both agreed unanimously that this was a close but clear win to the affirmative team. 3 issues that we saw in this debate. Firstly, on how these ideas are taught. Secondly, on how judges are likely to perceive this information. And thirdly, how does this conference impact the future? Firstly, on how these ideas are taught. The affirmative team come out strongly at first and tell me that it is likely to be taught through a neoliberal lens. That is, it is likely to be particularly pro-business, it is likely to be particularly anti-regulation, for 3 main reasons that I've boiled down to. Firstly, they tell me that these were the preceding sort of beliefs at the time. Secondly, they tell me that especially the type of people who are stated in the info slide are likely or propagate those beliefs. And thirdly, that specifically with lawyers, these people share a specific bias, so they're likely to propagate that. The negative team come back at me and say that is teaching is probably not always neoliberal, and they provide 4 reasons why that's true. Firstly, they say that some other economists were there too, so not all of them were neoliberal. Secondly, they say that this is the time where doubt about neoliberalism started to proliferate and started to exist. Thirdly, they tell you that the legal system already incentivizes you to like things like private investment. And fourthly, they say that because you're a judge, what is persuasive to you in court does not change. So this is likely to not have that much of an effect. However, I think that to the extent that I did credit this analysis, I think I had 2 problems with it. Firstly, it was largely mitigatory to the affirmative team's analysis. That is to say that especially when we heard concessions which were like, even if a large majority of these people are neoliberal, we still have some people that are not. I thought that when I weighed it up against the affirmative team's material, to the extent that we had like just more people on that panel who proliferated neoliberal beliefs. And secondly, to the extent that we heard that the most powerful people and the most experienced people were likely to be neoliberal, I was able to buy that the majority of the ideas taught were probably going to be neoliberal, and so I awarded that debate to the affirmative team. The second thing then is how do judges perceive that information? Because if the affirmative team can show me that despite this, panelists being super neoliberal, the judges are able to reckon with that and able to, not perceive that in that way and not let it affect their ruling, they are still able to gain some ground in this debate. What do they say then? The negative team tell me that this is likely to be taken well for 3 reasons. Firstly, the judges are smart because they have master's degrees and they're able to weigh knowledge. Secondly, that they have obviously studied some concepts in uni, so they're likely to take these ideas with a grain of salt. And thirdly, because you have economists from both sides who are likely to teach it well, and because they know how to proliferate discourse, so the non-neoliberal people are likely to want to, put their case forward. And the affirmative team gets back at this in a couple of ways. Firstly, obviously, we already have proven that a large majority of the panel is likely to be, neoliberal, and those ideas are likely to be like that. But secondly, they tell us that despite judges being smart, they also value reputation, and the people who are on this panel are likely to be the most accomplished and the ones with a lot of reputation, right? So that means that they are likely to pay particular importance to these ideas. Secondly, they tell me that these judges have less knowledge about particular complex economics theorems in the counterfactual, and so now you expect lawyers to fully demonstrate your arguments. Thirdly, they tell you that these judges had an incentive to listen to the panel because, firstly, it was opt-in, and also because, it was particularly luxurious or whatever, and they had an incentive to learn. While the negative team are, probably right in telling me that judges are smart and able to weigh up these decisions, I think that there are 2 reasons why I still am able to believe that overwhelmingly the judges who do perceive this information are likely to perceive it in the neoliberal lens. Firstly, I think the analysis that the negative team tells me on, why these judges particularly value reputation is good. And secondly, I think the analysis that we hear on why it is particularly likely that these judges or value that is particularly good. So at the end of these 2 issues, I believe that firstly, the types of ideas that are likely to be proliferated are likely to be neoliberal. And secondly, that judges do not, use their own biases to reduce the impact of that. Thirdly, then, on how this conference impacts the future. And I think that there's a lot of discussion in this debate about whether, negative teams' future benefits count or not. And when I weighed that all up, I think that it was probably right that you cannot change the conference and make it better in the full future. But I think that you can probably improve it over the time that it exists. So I think that we came to a consensus that the conference happened a couple of times during a certain time period. Maybe you can improve it from the start of that time period to the end of that time period, or that during the time that it exists, it had particularly good influences on judges and it made rulings better. I thought those were the 2 sort of distinct paths to victory that the negative team had here. And how did they try to prove them? They tried to prove them through 3 ways. Firstly, they said that as judges started going to this conference, they see better discourse, and that improves things like only listening to precedents because you diversify the amount of ideas that happen. Secondly, they tell you that people running the program are good at getting their ideas out, and as more non-neoliberal people come in, they will be more likely to get their ideas out. Thirdly, they tell you that it opens the door for other professionals to come in. And lastly, we hear that there is a contention in the affirmative team's case. Because they say that the conference can't be influential, and also happened a long time ago. While I sort of understand where that line of analysis is coming from, it is hard for me to buy that because I think that the argument that the affirmative team was presenting was that the conference happened a long time ago, but the impact of that conference was particularly large at the time, and it has continued for a longer time period. What does the affirmative team say on why this is particularly bad for the future then? Four main things. Firstly, that you are likely to have lots of conservative biases. Secondly, that judges are likely to be more punitive and not believe that people are rational when they commit crimes. And they say this is particularly bad because people are not always rational. The negative team do come back at this by saying that judges are also human and able to perceive these biases, and I think that is particularly true to some extent. However, I think that to the extent that we prove that there is a certain facet of judges that are buying into neoliberal ideas, I have to weigh that these particular types of judges are likely to sort of be particularly punitive. While I do accept that there's probably a second set of judges who exist outside of the conference. Firstly, there was little characterization on what those judges looked like. And secondly, I think that within the scope of this debate, most of the importance was placed on the judges who were, impacted by that conference. The next thing that the affirmative team told me was that judges don't break up monopolies, and thirdly, that they're more vulnerable to be lobbied by businesses, so they're less likely to rule in favor of workers, and fourthly, they're less likely to defend intellectual property. At the end of this issue, I think that the affirmative team are able to show that the conference is likely to have particularly perverse effects on judges' ruling. And while I think the affirmative team is able to mitigate that to a large extent when they show that, not all judges will buy into this, not all things are neoliberal, I think that only narrows the margin, but does not take it completely onto the negative team side, because I think that there is still an overwhelmingly large amount of biases that these judges take, and I think that there is an overwhelmingly large amount of neoliberal ideas that are proliferated. So I wanted this debate as a panel on a close but clear decision to the affirmative team.